Hi, Sarma. We can start with the session.
Yeah.
Perfect, Prof. So, good evening, every dignitaries. Thank you for joining us. It's my distinct honor and privilege to welcome each one of you to this timely and significant webinar on implications of the Supreme Court 3-year practice rule for judiciary aspirants. Today, as legal educator, aspirant, and stakeholders in Indian judicial ecosystem, upon a decision that is poised to reshape the journey of the thousands of future judicial officers across the country. At the very outset, I would like to extend my heartfelt gratitude to our esteemed speakers, Honorable Justice J. Chelameswar, sir, former Judge Supreme Court of India, Honorable Mr. Justice Navniti Prasad Singh, sir, former Chief Justice, Kerala High Court, Professor D. Surya Prakash, Honorable Vice Chancellor, DSNLU Visakhapatnam, Professor Dr. K.V.S. Sarma, Honorable Vice Chancellor, NLU Assam, Mr. Sanjay Kumar, District and Additional Session Judge, Katia, Bihar. And also, we have joined us a leading judiciary coaching because we thought like the aspirations and the need is only understood by judiciary coaching, where they have the lakhs of judicial aspirants who are preparing for judicial service entry. Your presence today not only elevates the academic rigor of this discourse, but also brings unmatched depth and clarity to the topic that demands nationwide deliberation. The 3-year practice rule, as laid down by the Honorable Supreme Court, has sparked a wide spectrum of reactions from deep concerns to cautious optimism. On one hand, it reinforces the foundational value of practical legal exposure before entry into the judiciary. But on the other hand, it prevents aspirants from a longer and possibly more uncertain route to what has traditionally been seen as a direct post LLB career goal. It is very essential that we understand that this is not just as a procedural mandate, but a transformative shift in how we prepare judiciary for the future. As the founder and CEO of the Club of Law Students, I have seen firsthand the anxieties and aspirations of our law students and early practitioners. This webinar, therefore, is not just a response, but a responsibility to provide a platform where students can hear from the best minds in the field, engage with ground realities, and most importantly, gain clarity in this period of uncertainty. To our attendees, students, professionals, and educators themselves, I urge you all to approach today's session with an open mind and a keen ear. Let us question, learn, and equip ourselves with both perspective and purpose. Let us begin this crucial dialogue. Thank you and welcome once again, sir. To, Mr. Chinmay Pandey, who is Senior Judicial Faculty at Textbook Judiciary Gold, will be moderating this session, sir. He will be posing some relevant questions which are coming from the lakhs of judicial aspirants who are suffering, who are getting deviated from the judicial service entry because of this judgment. And I understand the purpose and the relevance of this judgment, and I request the dignitaries to shower the blessings on us. Thank you so much, sir. Uh, Justice Shamleshwar, Justice Navniti, Professor Dr. K.V.S. Sarma, Professor Dr. D. Surya, and Mr. Sanjay Kumar, I welcome you all. I welcome you, sir.
Namaste, sir.
Over to
Sir,
you.
I'm Chinmay Pandey, and for past 5 years, I've been mentoring the students who are aspiring to become a judicial officer in India in different states. So, sir, on behalf of those students, and as well as on behalf of myself also, because I have been an aspirant too for a very long period of time. Sir, I have certain questions with respect to the scenario which has took place after 20th of May 2025. Uh, Sir, I really want to know what is the policy rationale behind this judgment. Reason being, a lot of aspirants take admission in law colleges, considering the fact that just immediately after graduation, they have a very good scope with respect to judicial services. And at the same point of time, it is a job which provides financial sustainability and financial security for them. Sir, so my very first question with respect to this is, what is the policy rationale behind this judgment? If Justice Chelameswar, if I start with Justice Chelameswar, so what is your opinion with respect to this judgment?
Oh, good evening to all. Now, policy rationale, obviously, you'll have to call out from the judgment. I can't substitute a policy for what is contained in the judgment. Now, the Supreme Court has, in substance, placed it on the experience of last 20 years after the earlier judgment, after Justice Shetty Commission report. The Supreme Court had an occasion to consider the report and issued directions that the practice is minimum requirement of practice need not be insisted upon. Now that is the situation prevailing for the last 20 years. Now, if we read the present judgment, the Supreme Court puts it on the ground, the experience of the last 20 years. Various suggestions or factuals and statements were made. I don't want to go into them. It's not a critique of the judgment. We are sitting here. The point is, the Supreme Court called for the views of the various high courts and state governments. There was no uniformity of view in these matters. Different high courts gave different suggestions, they gave different opinions, different state governments gave different. That was the situation even on the earlier occasion also, even before Shetty Commission and later in the Supreme Court. So eventually, well, naturally, whenever I have a larger question on this, but I don't want to say. One question is, earlier Shetty Commission made a recommendation saying that, in fact, at 8.35, paragraph 8.35 of Shetty Commission recommendation, some seven, 8 lines after the beginning of the paragraph, we consider that it is proper and necessary to reserve liberty to the High Court and state governments, as the case may be, to select either advocates with certain standing at the bar or outstanding law graduates with aptitude for service. It is not correct to deny such discretion to the high authorities like high courts and the state governments, which perhaps is a very, very healthy understanding of the constitutional scheme and the problem. Because the situation all over the country is not identical. Every territory, every high court has its. In fact, I may tell for the benefit of the members participating in the thing. The only Chief Justice's conference I attended in 2008 as Chief Justice of Guwahati. The next conference, unfortunately, I couldn't attend because of health reasons. Thereafter, there was no conference for 2 years, and afterwards I reached the Supreme Court. That's a different story. Now, when the then Chief Justice of India was making certain suggestions which are required to be followed by all the high courts. In fact, I had to tell the gathering of the Chief Justices, my colleagues, then, please remember that all the high courts are not identically situated. For example, I was serving the high court with 7 benches as on the date. Subsequently, now there are 3 separate high courts, Manipur, Meghalaya, and this thing. Now, and I had 7 different governments to deal with, 7 different sets of rules for the employees of the High Court, because each one of them is an employee of a different state. In fact, I had an interesting repetition before me, where the deputy registrar of a particular bench filed a repetition saying that in so-and-so state, UDC draws more salary, his pay scales are, but because that particular state, Tripura was a communist government those days, more friendly to the employees. So, this kind of problems. Therefore, trying to apply uniform standards all over the country perhaps has its own problems. And the same principle, in my view, holds good with reference to this also. And Shetty Commission, with the utmost respect to Justice Shetty, very properly and wisely suggested it's better to leave the discretion to the high courts. Well, anyway, now it is the law declared by the Supreme Court, all of us are bound by it. That's a different matter. It's one area. Because ultimately, it's all based on experience. There can't be any hard and fast rule in these matters. It all depends on you made an experiment for 20 years in this country, and now the Supreme Court comes to believe, after taking various inputs from various bodies, states and high courts, that this system did no good, that no practice requirement. So didn't do any good to the system. Therefore, there is a need to reintroduce. Well, we have to accept some system. And the problem which youngsters may face because of the introduction of this rule is only a minor consideration, according to me. I may be pardoned. I don't want the youngsters to get offended. Please remember, my dear young lawyers, please remember that the system does not exist for us. We exist for the people. So what is good for the people ultimately is the question that is the test. Now, incidentally, we are there and we derive some advantage, some salary, some office, all those things are different matters. Then you may have to wait for some time. But per se, I don't find anything very objectionable. But if somebody were to ask me for my opinion, unfortunately, nobody asked my opinion before there's any commission or anything like that. I would prefer a longer training course. Okay, recruit raw graduates. Put them to 3. In fact, Shettigam said minimum 1 year and up to 2 years. And most of the states had it only 1 year. I would rather prefer a more intense course for 2-3 years. Because I know, I'll tell you why I'm saying this is this. That there is a great deal of truth in what the Supreme Court observed. Forget about the junior civil judges. I'm sad to say this, but it's a part of the Supreme Court record. Perhaps the last judgment I penned in my career. A triple murder case from Gujarat. Obviously, 302 cases are old 302, whatever is the change number, I don't remember now. Old 302. 302 cases are heard by the session judges, where there is a requirement of minimum 7 years of practice. And it's a matter, it is recorded in the judgment. The learned judge framed a one-line charge. 17 people are charged with offences under 143, 144, 147, 149, blah, 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 302, 307, so on and so. And I suppose any serious student of law knows in criminal law, the charge must be specific. And which one of the accused, 17 accused, which one is charged under which particular offence? Nothing is there. An omnibus charge was framed. If that is the situation but I'm not saying this is the state of affairs across the board, all the officers, and these things also happen. That's all I'm trying to point to. So therefore, some assurance. Ultimately, people come to us with the hope that we'll do some justice here. They recommend it's better. Our credibility depends upon the quality of the service we render. Some kind of assurance that these are youngsters, boys or girls, well trained in law. I certainly don't expect somebody who's aspiring to be a junior civil judge to be a Baba Saheb or Saraladi or Palchiwala, but as a minimum degree of equipment and competence certainly are expected. In the larger public interest, that is a must. So therefore, well, a new experiment is started after 20 years. I do not find anything objectionable about it. In the sense, objectionable, that's okay. It might cause some hardship for the youngsters. Immediately, they may not be able to secure a job. But then there's the case with some of our previous generations. This was there, well, it's part of the system. In fact, the Supreme Court itself noted, for a district judges, 7 years requirement is there. For High Court judges, 10 years requirement is there. Why not? That's also a logic. That's a way of looking at things. So, in substance, that's my opinion. Maybe on any further discussion, we'll see. But the policy rationale appears to be this to me, as discerned from the judgment.
Yes, Justice Navniti Singh, sir, so what is your opinion with respect to the judgment, sir?
Good evening, everybody.
Good evening, sir.
Having been Chief Justice of High Court, but of course for a much lesser year than Honorable Justice Chelameswar,
Oh, mine is a unique case, brother.
You have been Chief Justice multiple times at different places and a wide experience. I was there for a short time, but as a senior judge at Patna, for a long time I had the occasion to deal with these matters. Now, my experience is that firstly, people have to realize one thing, that the system is not meant for them. They are meant for a system which is designed for dispensing justice. It is only by way of necessity that you are there and you are paid for it and you look to it as an employment. But the system has a purpose. It has a sovereign purpose. Not like a secretariat office file, but a purpose where you have a power to punish. The moment you qualify, trained, and you get it onto your desk, you have the power to impose a penalty on a person as a magistrate class 3. Within 6 months or a year, you will come to class 1, where you can put a person behind bars. You have the authority to decide the freedom and liberty of a person, right of property. Now, those decisions have to be a mature decisions and not a out-of-pocket decisions. So before you can take the position of a judge, you must have maturity and you must know the system. Now, taking an ideal situation, a person with the 3-year rule now in place would join the lower judiciary, the junior division. I'm sorry to say lower judiciary is no more there. It's the junior division, would be at a young age of 25. Now just think, a person, a lawyer even, of 25 years of age, how many clients would readily come up to him and entrust him his case? They would always look to a senior whom you will be assisting. And here to say that at that age, you take a power to send a person behind bars and with no answerability. Now, that's a very dangerous situation where a person who is not fully matured, understanding the worldwide implications, who does not understand the system, to be given such a power. Now, straight after law school, what do you learn in law school? I don't think so. Law schools are of any importance when you come to practice, except familiarity with the legal provision. Practice is something different, altogether totally different cup of water. You have to start from scratch. It is advocacy. It is how to judge things, how to decide what to do. Now, those things are not really taught in law colleges. Here, you have to take a decision as a judge. Now, when you don't know the system, how the system operates, what are the public aspirations, how you deal with people, and you get that sort of a power, you're likely to go berserk. Now, merely because you had been expecting that straight out of law college, I will take up this as a job. Now, that is your perspective. That is not system requirement. System requirement is someone competent, mature to do justice. And unlike executive office files where you have बड़ा बाबू इसमें क्या करना है, बड़ा बाबू नोट बना के ले आइए. You ring up your senior, sir इसमें क्या करना है, or the senior rings you up कि बाबू इसमें you have to do a thing like this. Here you have to sit on the table, hear a person, hear the arguments, and take a decision, right or wrong. But that is a very responsible position. Don't ever take it or think from the line of a job. That this is a job profile and this is a thing I have to do. Because the moment you start thinking that the judge's role is a job, then you're not doing justice. You are dealing with files. And that is the last approach you have to have. Now, before this judgment, initially, after the constitution came and all the state governments were given the powers to frame rules in consultation with the High Court for the subordinate judiciary, there was a requirement. In some states, it was 5 years. In some states, it was 2 years. Recommendation came from Shetty Commission, and different states started doing different things. Ultimately, what the Supreme Court has said, no, experience has shown that they must have an exposure. Because, you see, the moment you graduate from law school and become a judge, as a magistrate even, you are seeing only one side of the system. You have not seen the other side. You don't know what actually happens there. What happens to the client? How you are supposed to deal with the client? What is the approach of the client? What a lawyer does? How the system operates? How do you file a suit? How do you make choices of pleas? You have absolutely no knowledge. And now, without knowing the system as a whole, you just jump in from one side, and that too to sit on the table. Now, that is the consideration if you read from paragraph 53 onwards of the judgment of the Supreme Court. That essentially, that is the situation. The Supreme Court says, no, you need time. Now, if a boy intends to join the service, he passes out from law school at the age of 22. How many of us, even as a lawyer, could even make any money at the age of 22? You want to get into service at the age of 22 and draw a starting salary of something like 75,000. As a junior lawyer, except for metropolitan towns, in Patna, I'm sure a junior lawyer, he wouldn't get 75,000 till he was 30, 35. He couldn't even dream of that. So now, coupled with the age, the maturity, and knowing the system, I don't think so. Principally, there is anything wrong. Yes, there is only for a couple of years people who are aspiring. So 1 batch, 2 batch, or 3 batch, that aspiration, now they have to wait. But otherwise, it is restoring what was there before. And the practice, because I have seen, Justice Chelameswar must also have been associated with the Judicial Academy. I had been chairman of the Patna Judicial Academy for 2 years, planning courses and all, and I saw the boys who come out of law college and join, they are really raw. First, we decided that there will be no academic teaching, because that 5 years they have done at the law faculty, in the law college. But believe me, experience showed that even that basics of law, they lack. So much so, I being a member of the Bihar Public Service Commission interviewing students, applicants for the junior division, I just very casually asked someone, we normally use the Evidence Act for criminal trials and examination, cross-examination. What is there for a civil suit? And believe me, 5 students I asked, and none of them could answer. And all of them, they've done their 5-year faculty. Now you expect that such boys tomorrow should sit down and start dispensing justice as magistrates. Now that is why it is essential that spend some time in the field. Pick up what the system requirements is, what the system, how the system works. Get to know that. But I know, unfortunately, even those 3 years, you will sit at home, tuition classes, and keep studying. But then the idea is different. That yes, you do study, but get into the system. Know the system. Only then can you start working and find ways. So I would say that, yes, your aspiration to get a job within a year or 2 of graduating is lost. But that is with a good purpose.
So
Thank
my
you.
Okay, sure. So my following question is with respect to the women candidates, because time and again, Honorable Supreme Court as well as various high courts have emphasized on the point that there should be more representation from the women at the district as well as high court and Supreme Court level. So, sir, for last 2-3 days, I've been in touch with more than thousands of students, and among them, a lot of candidates are women. And the main question is, once we get graduated, it is 23 or 24 years of age, and जो societal pressure होता है, the societal pressure to get married, which pressurizes the parents to not to now proceed towards judicial services examination, is affecting their career prospects as well as their aspirations. So, sir, what are your points with respect to women candidates? Because hundreds of women candidates are watching you with respect to this. So what is your message for those candidates? Because they have been, their career is now in doldrums, their aspirations are now in doldrums after this judgment. So, sir, please speak to them with respect to this point too as well. Both.
Is that question to me?
Sir, everyone, like Chelameswar sir, Navniti sir, both. Chelameswar sir, आपके क्या views है, sir? Women candidates.
Okay. Because the girl candidates or women candidates, of course, at the age of 72, I can still call them girls. Okay.
Yeah.
Now, the girl candidates, that this particular judgment comes in the way of the pursuing their life, and that is not a relevant consideration at all. On the other hand, my personal experience in this is that this statement that women are underrepresented it is once again is not uniform in the country. Both Justice Navniti and I know, both of us had the privilege of serving the Kerala state as Chief Justice. It's the lady advocate do very well. And you check up the averages there, they take the statistics from the service. Of course, when I retired 7 years back, I left Kerala 2011, some 15 years back. I don't have the latest figures. It is a substantial number of women officers are there. In fact, at one point of time, I made a public statement. I believe by 2050, the judiciary, especially the judiciary below the high court level, would be dominated by the women. That's my belief. I'll tell you, 2007, before I left to Guwahati as Chief Justice, in Hyderabad, there was a recruitment process for 10 posts of district judges. I'm talking about district judges, that particular thing. Of the 10, 5 girls got selected. Andhra Pradesh, old Andhra Pradesh state, had a reservation in favor of women, 33% in all services. 2 girls came on their own merits on the top of the list. 3 girls came under the reservation quota. Of the 10 posts, 5 posts went in favor. So therefore, the experience is not uniform in all the states that the women are underrepresented in judicial service. Now, it can vary from state to state. I am conscious of that fact. Now, but the answer is, well, I don't know what exactly. Therefore, if we don't accept this system of 3 years practice, how would it be better for women candidates? I mean, how is it going to improve their opportunities? Ultimately, they'll still have to face an examination. Question is, you may have to wait for 2, 3 years. Well, this is a problem in the country where employment is a huge issue, not only in judicial service, in every service in the country. How many people get employment after education? I'm sorry to say, but I'm not trying to disparage anybody or discourage anybody. I'm sure Brother Navniti Prasad will bear me out on this. When I was the Chief Justice of Kerala, a recruitment took place for the Class 4 posts in Kerala. Some 20,000 applications came, and to my shock and sadness, I noticed in the information when data was compiled, some 200 or 300 engineering graduates applied for Class 4 posts. That is the state of affairs. No, I'm not saying, therefore, there is justification that women should wait. Making these sentimental issues does not help us. Let us keep these sentimental problems aside. We are looking at a particular legal framework. Is it inherently wrong? Or does it serve some purpose is the only question we should look at it, at least as lawyers. And of course, I take Brother Navniti Prasad's views.
Now, my first objection to all the judgments and public statements is when people say that women are underrepresented. What do they mean to say? Are they accusing the system of not selecting sufficient number of ladies?
What else are they doing, brother? Of course, they are doing it.
No, then where's the question of saying unrepresented? That means if the ladies don't choose to come in sufficient numbers, what do we do about it? Now, Brother Chelameswar was mentioning about Kerala. Who was the first lady judge to come to Supreme Court?
Fatima Bibi, Kerala.
From Kerala.
And incidentally, for the information of all those who are criticizing, India had the first women judge in the Supreme Court much before the United States had the first women judge in the Supreme Court. So it is all.
Now, it's a career choice. You see, after graduating, a career choice has to be made. Now, you don't say that the system-wide selecting is biased in any manner. Now, if fewer number of ladies apply, fewer will get selected. Then why do you blame the system and say reservation? Reservation will not get them anywhere. It's the merit that will get them. So ensure that more and more ladies take up study of law. And now you'll be surprised if you go to any of the law faculties, law schools, the number of ladies, girl students, that has gone up tremendously. Earlier, if the ratio was 1:10, now it's almost 1:40, 50 and 40. That much, it's gone up. And with that, number of people stepping into the services, girls, are going up. But I think your question was otherwise. Your
Yes,
question
sir.
was that 3-year postponement
Yes, sir.
may become detrimental to their employment opportunity.
Ji, sir.
But then that is a social choice you have to make. You have to persuade your parents. Again, don't blame the system. If the parents say that you are sitting idle for 3 years and you should get married and you can't resist that, don't blame the system. The parents must have faith in you that yes, 3 years you work hard, you'll get into the service and then we'll get you married.
Ji.
And after marriage, the problem then starts all over again.
Husband saying something.
No, the girl's family coming and meeting the judges कि सर इनका पोस्टिंग यहाँ कर दीजिए, इनकी शादी यहाँ होने वाली है. Now husband is in business or something somewhere, तो उनका पोस्टिंग यहाँ करिए. But that's a career choice you've made. Maybe once or twice one may do something and get you there, but then you have to be separated. Now we find that also a big problem because after 10 years of service, we are finding that ladies are dropping out. Now those are problems of individuals. It's not a problem of system. System does not discriminate. If you have the legal acumen, if you have the intellect, you'll qualify, you'll get selected. Whether to marry or not marry is your personal problem. Don't make it a systematic problem.
And Lordship, so far financial condition is being concerned, Supreme Court has given the freedom to them also, like to apply for the job of law clerk or research associate to any judges or judicial officer.
Supreme Court has not given, the law has given. Supreme Court
Yeah.
has only reminded you that it is
Reminded.
available.
Yeah. So there is a freedom.
In addition to it, like what Sarma just said, like this freedom has been given to a law clerk, that is a law researcher, which is employed either in the Supreme Court or the High Courts or the tribunals. My question is, sir, there are a lot of students who get themselves enrolled, but later due to financial constraints, they join other organization, banking organization as an in-house counsel, or other than in-house counsel, we can say that as a law sorry, not a law researcher, but as an in-house counsel, they join as a banking service. Like आपके जो IBPS special officer exam होता है, SEBI law officer exam होता है. So with respect to those candidates who initially joined these services to support their family with respect to finances, their contention is that for these many days they are working there and gaining an experience of the procedure and the courtroom functions in the tribunals. Their contention is that due to this judgment, their aspiration as to become a judicial officer is also getting hampered. Like, so what is your take with respect to this?
Aspiration, no one can help. You can aspire anything.
Ji, sir.
Again, I go back to that, the dominance of the system theory. It's
Ji.
a system requirement
Ji.
that is dominant and not individual's aspiration.
Ji. Sir, but my question is with respect to...
You see, individual always will look for a comfort level.
Ji.
Now that may always never not be conducive to the system's requirement.
Ji. So my question is like, can we consider a person serving in a bank as a law officer or SEBI or RBI has less practical knowledge than a candidate who is practicing as an advocate in a courtroom? Like, my question is with respect to it, because this judgment clearly bars those candidates who have already get themselves employed in other regulatory bodies as an in-house counsel or as a law officer. So
the requirement again is system requirement.
Ji, sir.
As an in-house counsel, you have no exposure to the system.
Ji. Okay.
That is the difference.
Okay. So we have Professor D.S. Prakash Rao, sir, and K.V.S. Sharma, sir.
Can I
Ji,
say something in the
ji, sure.
context of the last question?
Ji, sure, sir. Ji, Lord.
See, you're talking about employment in the bank or somewhere else.
Ji.
The legal position obtaining as on today in this country is, once again, for district judges. In fact, the problem arose from Brother Navniti Prasad's High Court. Sometime, some 25 years back, 2 notifications were issued, one for district judges, one for junior civil judges. Now, candidates applied, some of them applied for both the things. The selection process of the district judges ran into some trouble. There were questions and writ petitions in the High Court, Supreme Court, a lot of things happened. These are all reported judgments you people can read. In the meanwhile, the junior civil judges selection process went on. Some people became successful. They were appointed. They were working. Eventually, when the litigation settled down with reference to the district judges, 2 candidates who were successful as junior civil judges who also appeared for the district judge selection process found a place in the merit list. The High Court issued a letter calling upon them to come for interview, YOC, with a condition that you resign because under the Article 233 or 34 numbers, I'm forgetting, 34, somebody in employment of the state can't apply. And a judicial officer at that level is also an employee of the state. He is an employee employed by the governor. So the High Court advised them to resign and come. They challenged, look here, we don't know we are going to get selected or not. If we lose this job, we don't get that, we lose both the ways. They challenged it. Unfortunately, the High Court rejected the challenge. The matter came before a bench of me and Justice Sapre. We do a distinction. In service law, there is a distinction between selection and appointment. Every candidate selected need not be appointed as a matter of legal principle. There can be various reasons for which a selected candidate may not. Suppose there is an adverse intelligence report saying that this man's personality is questionable. And various reasons. So there is a distinction. So when they're called for interview, it's still a selection process, not it for why should they resign, we said. But unfortunately, well, within 6 months after my retirement, the judgment was reversed. So somebody who is actually serving, you're talking about somebody being employed in the bank.
I must confess,
brother,
that was a decision of the collegium of which I was a member.
Brother, I'm not making any.
Now,
I'm only trying to say, if somebody who is serving as a judicial officer is not found to be qualified by the Supreme Court ultimately today, though we held that they should. It is selection. I'm not even saying appoint them. You can ask them to resign before they come. This is a technical requirement that they should not be in service.
Your Lordship judgment was very clear that once they are selected, they'll have to resign to join.
But unfortunately, that was overruled. Within 6 months after my retirement, it was overruled. No, I'm not finding fault with any. I'm only trying to say, so therefore, don't think that only those who are working in the bank are into this trouble. Even those who are actually. In fact, this requirement of 3 years practice, brother. In fact, you remember the judgment, earlier judgment of Supreme Court penned by Justice Lodha before he became the Chief Justice. Justice Lodha interpreted 7 years in the immediate past. If there is a hiatus in between, he said it would not be considered as this thing. So somebody who gets into judicial service, this question must still come. Look here, you didn't practice 7 continuous years immediately before the selection. All his 3 years of experience as a judicial officer, and somebody, without meaning any disrespect on the lighter vein, somebody who goes to the bar association for 7 years regularly, has a chai and discuss politics, becomes qualified at the end of the 7th year to compete for the district judge post. Somebody who has been a judicial officer for 6 years, he will not get this benefit. I don't know, it's a weird system which requires a re-examination sometime. Sorry, we can proceed with the next question, General.
So basically, sir, like we can have this inference that we are in the system.
It's breaking. I'm not able to hear you. There is some problem.
There's a
Am I audible?
connectivity. Yeah, you are audible now.
No, someone has got 2 systems.
I'm not. So yeah. So we can infer that we are living in a system where justice is to be served at large. And not even the public, general public, but when this edges was concerned, even the judicial officers were not permitted to give the edges at this when they are already in the service. So, like, whenever this justice is being concerned, justice is primarily not the sensitive issue of the people or the particular community or something. So, moving ahead, sir, uh, we are we are privileged to have Mr. Sanjay Kumar also, who is district and additional session judge. And my question to you, sir, is like when you see the young magistrates who come for you to have this probation period, probation under you, under training under you, and what are the practical implications and the knowledge so far the knowledge is being concerned of the magistrates and the junior division civil judges, and how do you see this judgment as a essential and prospect towards the justice serving society? Sir, over to you.
Good evening, Lordships, Honorable Chelameswar sir, Honorable Navniti sir. Before saying anything, I would like to impart something. Navniti sir, I have been your one of the a student as a judicial officer when I was being inducted in a training program at BGA. So I have great privilege that this forum gave me this opportunity to interact with you all. And thanks to Honorable Chalmeshwar sir, 2 times I have written edges when I was in service because only because of your judgment we were allowed to write exam. Although this was overruled later on. Uh, my warm regard and pranam to all.
There's
Sir.
nothing personal. Then nobody need. We have done our job. There's no personal favor done or personal harm done in any one of these matters.
And sir, very warm regard to eminent jurist Professor Dr. D. Surya Prakash Rao, Honorable Vice Chancellor, and Professor Dr. K.V.S. Sarma, Honorable Vice Chancellor NLUJAA, and other these two young boys and other participants who are viewing. Thanks to you all. Sir, we have been taught and we have been time and again told by our gurus, experience matters. And it is also stated and firmly rooted in belief that wisdom is daughter of experience. Wisdom does not come all in sudden, automatically. Sir, if we talk about, not talking about law graduates, if we talk about simple graduates, after plus 2, they undergo 3 years graduation program. After that, they came out and try for different services. They might be in secretariat jobs, other gazetted posts like IPS, IAS. And after doing graduation, as we did, we again underwent 3 years for next graduation course in law. Studied in law and trained in law, both are different things. Even though we do double graduate, or what to talk about nowadays, when plus 2 boys and girls both go to join BLLB course, 5-year integrated course. So they are very raw as compared to those who have completed 3-year LLB course. Sir, this has been rightly stated by Honorable Navniti sir. Even at the age of 35, if a lawyer is not getting 75,000 bucks, cannot compare with the judge. Sir, experience comes only from not by learning books. It comes from oneself involving in the matter. When going through practically, when their skill is being developed, and this takes time. This is not all in sudden. And in few years back, some appointments we have seen, law graduates, they have come, they go under training, they are very, very in a raw form. Qualifying judges examination to become magistrate, that is different thing, but becoming judge is a different thing. To become judge, it takes longer period, not even 3 years. 3-year barrier, this has been set by Honorable Supreme Court, as this was earlier too. 24, a boy, a girl, age of 24, 25, they come to induction program, they join their post. They get, in day to day, we are encountering with them while we imparting training to those fellows, practical problem. They don't have a skill. They know in literal word what is law as per bookish knowledge. But there is, sir, again I will differentiate, studying law and application of law is quite different. Sir, this is also bitter truth. Those who dare to undergo LLB course, their career will start or starts at later stage, in the age of 28 or 29, 30. This is not qualifying like a technical entrance exam like IIT or NEET, medical aspirants. They just qualify, they become skilled professional, they do highly technical mechanical job. Here, sir, from our bottom of heart to brain, we have to involve in the law. 100 times Evidence Act. Your interpretation will be finer and finer. Are these things, sir, possible to achieve in law graduate schools? Of course not. Unless or until we cannot understand what is the difference between may presume and shall presume and conclusive, we can mug up it. But while we are analyzing it, while we appreciate with the evidence, we can mess if we don't have skill. This problem is being encountered across our country. This is not a matter of a particular state. But of course, sir, I will not forget to mention here that there are some genius, brilliant students, but still I will tell, in the field of law, brilliancy and to be genius will matter hardly. Here we require hard working. Here we require skill consistency, day by day growth. This is not like that. We have completed IIT in 4 years and we got good perks. This is not like that. It requires more skill as compared to that. Even in civil services, sir, they cannot compare to judges. Judges' mentality. Because every day they have to deliver order, judgment. They have to decide fate. Here, sir, in younger age, directly getting appointment as a magistrate, sometime there happened to be, and this has been observed and seen, clash with the bar. They try to understand they are next to God. They are deciding fate. Sometime they feel biasless. If a lawyer utters something not suiting a judge, he may be biased. But of course, the way one gets grower, having gray hair, gets maturity, those judges get tolerability too. They bear, they try to cope up, they try to, I will not say negative word, handle or manage, but they go with the bar and bar appreciate too. So these are scenes, sir. Sir, one more thing I will tell you. When I was lawyer, I was practicing in a civil stream. one judge from lower judiciary had told me that lawyers are not pickles. As the pickle will will be older, they will brighten in future. This is not like that. But of course, that proverb may do, but to certain extent and to certain years, to certain times. So training, skill development, experience are required for these appointments, sir. These appointments are not this cannot be said to be service. This is something divine service. This is something imparting sovereign function to decide a person to be sent to behind a bar or not. This will give only because of experience of a number of years. If a session court dealing with session trial, sir, if experience is not required at all, what would be the analysis of the evidence? The same thing is applicable as well as to the appointment of a magistrate. They are also doing divine job, sovereign function. They are not like personnel in other services. Even IPS, IAS, they do their job. This would not be derogatory to them. But of course, I can say that they are doing their technical job. Here we do interpretation, application of law. So again, I will reiterate, studying law is different. Its understanding is different. To be selected as a judge is different. To become a judge is a different. This will take time. And sir, I would like to answer one question which query was done by Mr. Chinmay Pandey, that those who are aspirant and they have got appointment or they have service in banking sector or they are serving as a law manager, I would like to quote one judgment I had written, sir, in year 2012 AJS mains. I qualified to, and result was delayed only because of one judgment was to be delivered in favor of PPs, public APOs. But sir, the judgment is landmarking judgment, fabulous. Every chapter has been dealt, and I think if you go through, you will get every answer. Law manager, you must study this judgment along with the advocate's rule. Why additional APPs? Why they have been allowed? One answer was asked in that judgment whether what actually they do. They do representation on behalf of whom? Their client. Even though they are getting fixed salary, fixed remuneration, they are getting regular salary from the government, their appointment is government, but still they are working in court. Similarly, in the same parallels, managers, law officers, they have also been included. If you go through the judgment, you will get every answer of it. This is 69 to 70 subject to correction, 70 pages judgment. Full bench judgment, sir. This judgment was held in year 2013. Thereafter, we underwent interview.
Oops.
So experience, sir, matters. Again, I will reiterate. Thank you. Thank you, sir.
Yes, sir. Okay. Thanks so much, sir. So we have Dr. K.V.S. Sarma, sir. He is Vice Chancellor, National University, Assam, and Professor DS Prakasa, sir, Vice Chancellor, DSNLU, Vizag. So my question to both of you is that, like one time I asked this question to Professor N.R. Mathavan too. So I'm a graduate of National Law University, Odisha. So he was there in National University, Odisha, and there I asked him, the idea behind introduction of national law schools in India was to increase and the exposure that can be given to the law students and to supplement the bar and bench. But considering the fee structure of national law schools today, like in National University Odisha, today the fees is around 2.5 lakh rupees per annum, around. But when I graduated, it was around 2.1 lakh per annum. Uh, Almost around 50 to 60% of the students take education loan to support their education. And when they graduate, the easy monthly installment is around 50 to 20,000 rupees per month. And considering this amount of installment, and at the same point of time going for litigation for a period of 3 years, what are your views? Like, how does now national universities supplement this relation of bar with the bench? KVS sir, like uh, Prakasa sir.
So, good evening to all of you. Justice Chelameswar sir, Justice Navniti Singh sir, Professor Sarma, and other participants. Before answering this, I had to share the information regarding the statistics of Andhra Pradesh.
Ji sir.
In 75 years celebrations of Supreme Court, I attended the function where Supreme Court, the then Chief Justice announced Andhra Pradesh Judicial Service 2024, 66% lady officers were selected. So proudly said. And at present, in our university, 65% lady students are there. So we need more girls hostels than the boys. We have 800 students in our university, whereas 500 are girl students. And the other statistics I want to share, as a teacher of Dr. B.R. Ambedkar College of Law, Andhra University, where our Justice Chelameswar is proud alumni, for the last 5 years, I observed 25 judicial officers were selected from that college to Telangana as well as Andhra Judicial Service, out of which 18 girl students were selected. One girl student who was selected to AP Judicial Service, she was also selected to Telangana Service. She asked, she sought my advice, sir, whether I have to appear that interview or not. Then I advised her, please don't go there because you want to settle here. So if you go there, the post will not be filled up. So in that way, there is no dearth of girl representation or lady judicial officers representation. I know personally 3 or 4 people. One of my friend, she appeared 3 times junior civil judge examination, but she was not selected. After having attained 7 years experience, she was directly selected as district judge. Now she is High Court judge, also Andhra Pradesh High Court judge. So in this way, 3 years experience as our Chief Justice, former Chief Justice and former Supreme Court judge, their opinion is very valuable because within 3 years, what these fresh graduates are doing, they are joining into the competitive examination centers. So 0.1% may be this success rate regarding the applicants. And a student is spending 3 years or 4 years in coaching centers. And they are sometimes, if they get after 3 years or 4 years, that is a different one. But if the present Supreme Court judgment maintains the balance regarding not only the selection of the junior civil judge and senior civil judge, and from the junior civil judge to the merit was considered, and direct recruitment to the district judges also, a balance was maintained. And after having the experience of these 20 years, regarding the judgment, Andhra Pradesh High Court gave an affidavit. The fresh judicial officers selected were not giving respect to the bar as well as the supporting staff. That affidavit was submitted by the AP High Court to the Supreme Court. So 3 years experience, in my opinion, is an essential minimum requirement to understand the system. So as our Justice Navniti Singh also opined, so we are supplementing the system, not the people to be accommodated. The reason is, so judiciary is to be the purpose of this judgment or any particular policy is to improve the caliber of the judicial officers. So who can discharge the functions, who can deliver the justice system. So in my opinion, the present judgment is a balancing judgment, and considering all the opinions, all the issues, the present judgment gave a balanced judgment which can be helpful for strengthening the lower judiciary. In one occasion, Minister H.R. Bharadwaj, in one seminar, announced that I was the law minister who appointed as many as High Court judges and Supreme Court judges. Prior to the collegium system, he was the law minister. He was instrumental in appointing the Supreme Court judges and High Court judges. Now, the Supreme Court of India corrected the system, creating this collegium system. Now, reforming the lower judicial appointments, definitely this judgment paved the way to strengthen the lower judiciary to serve its purpose, that is to dissemination of the justice system. That is my opinion. As far as national university system is concerned, Professor Madhav Menon also once expressed the opinion. Actually, the law students studied in the national universities, they are preferring the placements in corporate sector and everything. At least less than 10% graduates from national universities are coming to the profession. That lacuna is there, that problem is there as far as the national university systems are concerned. But how we have to invite the law graduates to the profession. So law clerks are there. And of course, in this present judgment, the service of the law clerks is also taken into consideration for by applying the post of the junior civil judge. So that's why the issues are there. So whether it is a national university system or a traditional university law colleges or private law colleges, if you all of us are aware about the plight of the private law colleges also. Without going to the colleges, the people are getting the graduates, and some people may come into the system. Some unwarranted people also may enter into the system. So the 3 years minimum requirement may address the problem in a genuine way. This is my personal opinion. Thank you very much, sir.
My question is posing to Dr. K.V.S. Sarma, sir, Honorable Vice Chancellor NLU Assam. Supreme Court in the judgment itself cited in para 55 about the Law Commission report, which Law Commission is in the opinion, the report para is 4.6, where it explicitly says that Law Commission is in the opinion that the 2 years intensive training would outweigh the advantage, if any, of the 3 years practice at the bar, which often enough hardly helps in the matter of equipping oneself. So, sir, what is your view on 2 years extensive training module in the Judicial Academy rather than this 3-year law practice, where there is no financial security?
Thank you. Esteemed Lordships, Honorable District Judge, respected Vice Chancellor, and my dear young friends. And today, 2 questions they posed. I think your colleague also posed one question with reference to fees, abnormal fees. National law schools are charging, and students are taking loans to repay those. And your question is extending 2 years, what you call training program in Judicial Academy instead of 3 years. With reference to these 2 aspects, we have to go for and examine the history of our legal education and the legal profession. If you take before from 1930s, the legal education, if you take to become a lawyer after +2 2-year degree, law degree, eminent persons in ILS College, Government Law College, Madras, some of them, they became Supreme Court Chief Justice of India also after +2 2-year law course they studied. And some of them, they became eminent professors after +2 at the age of 19, they became advocates. And they started practicing Supreme Court. And several academicians at the age of 19, they started in what you call their teaching experience in law in universities. And later on, they studied degree. Well, that is a different issue. But after +2 2-year law course, they studied, and they became stalwarts also in legal profession. At that time, there was no apprentice also, 1932, 1950. Apprentice concept was not there. But slowly, after 1950s, what happened? This legal education, this Advocates Act they passed, and this Advocates Act says
1961.
Advocates Act says that is 1-year apprentice is mandatory according to section 24, what you call this subsection 1F. Apprentice is mandatory after completing what you call the 3-year degree. They converted 2 years into 3 years degree. After +2, what you call degree course, the candidate has to study. After degree only, law degree, he has to join for law degree. And after that, apprentice also Advocates Act prescribed. But this particular aspect they omitted in 1973, apprentice concept. And after law degree, directly they were enrolling themselves as advocates and they are practicing in courts. And the system, what you call, was going on 3 hours, 2 hours. The law colleges, they are teaching. And evening colleges, morning colleges, 7 to 9, they are teaching. Government employees were joining. And legal education standards were deteriorating, the experts, they thought. So in order to enhance strengthen the academic standards of the legal education, in the year 1986, the then Chief Justice of India, Ahmadi, and all Chief Justices of High Courts, law ministers, law secretaries, they conducted a conference in Bhubaneswar, and they decided to establish one national law university in each state. They have to pass a local act, but it must be national in character. It should be mainly controlled by the judiciary. Chief Justice of India is the Chancellor or Chief Justice of that particular state. But one particular point they said, no question of the university should not take support, financial support from government. Government did not give any financial support except infrastructure, land and buildings. That's all. Maximum these two only government should give. On the basis of that, first Karnataka state, they started National Law School of India, University, Bangalore, and Professor Madhav Menon was appointed as first Vice Chancellor, and he started this law school in garage in Bangalore University. And he mentioned, but to purchase books, he was not having money. So he took photocopies of all foreign editions and maintained like that. In those days, 25,000 rupees fees they used to charge from National Law School students in Bangalore. And in those days, 25,000 itself was a huge amount, 1988, 86, 88, because in universities they were charging hardly 400, 500 per academic year. When I studied my law during 1980-83 in SK University, Anantapur, Krishnadevara University, I paid 90 rupees per year. And 1986-88, when I studied my ML in Andhra University, 100 rupees I paid. For 2 years, 200 I paid. But now in universities also, they increase their fees to 35,000, 40,000 like that, in case it is merit seat. And 25,000 fee is very difficult to pay salaries, UGC scales and all this. And to maintain the university, it is very difficult. And so, National Law School of India University, slowly it increased the fees up to 1.5, 2 lakhs. Otherwise, they can't pay salaries. They can't pay they can't meet other expenses because governments are not supporting. These national law schools, even today, majority law schools, they don't get funds for other expenses. They have to raise their what you call teaching salaries and other expenses through fees only. So universities are compelled to charge this fees 1.5 or 2 lakhs. Otherwise, law schools can't survive. Even today, we are facing so many problems with this. These amounts are not sufficient for us. And as far as students are concerned, they are taking loans, you are telling. If you see, first 5 top law institutes after 1986, 1998, Nalsar, we started in Andhra Pradesh, the erstwhile state of Andhra Pradesh. Then immediately same year, Bhopal, NLU Bhopal, they started. Then Jodhpur state, the state of Rajasthan, they started. Then Gujarat started. Slowly every state started. And until 2013, Maharashtra state did not start any law school. Suddenly they started 3 law universities in Aurangabad for Marathwada region, in Western Maharashtra for Western Maharashtra, Bombay, and for what you call Vidarbha, Nagpur, 3 law universities they started. Now in UP, if you see, we have Allahabad and Jabalpur. Bhopal and Jabalpur we have. In UP also we have 2 law schools in Allahabad and Lucknow. So slowly other law schools in the same state also 2 or 3 they are starting. And with reference to what you call law school in Mumbai, I will tell you, till today, every month they are paying 3 crores rent only to MTNL building. 3 crores rent. And from where they have only 2 sections. Students' fees they can't. Unless government supports, difficult for them to survive. So Maharashtra is rich state and it is supporting generously. That is a different issue. But the students who pass this 5-year law course, first 6 to 7, other law schools I am not saying, first 6 to 7, when I was working in Nalsar, my students, Bangalore students, forget about it. Once they come to 4th year, they get appointment orders. Minimum 2 lakhs per month salary or to 24 lakhs salary they get. Big law firms, big private sector, they were giving employees were not having students. Bangalore, even today, same problem. They are facing, employers are facing. They don't get National School Bangalore. Similar to Nalsar also, in 4th year itself, from US, UK, Canada, Australia, law firms, they come. And they came and they issued appointment orders. $40,000 or 30,000 pounds like that. And our students, they got placements. And when they secured placement in public sector and private firms or private sector, they were preferring this particular private sector and law firms instead of government. Once SEBI chairman Damodaran came to Nalsar and he requested all students, I will not conduct any written test, I will conduct interview. Please join. I will give you 40,000, 25,000 salary and free flat in Mumbai. Please come and work for SEBI. And they sent a team. They selected 8 candidates. Not even a single student joined SEBI. When I asked them why you did not, sir, in ICSI we are getting 18 lakhs. In HSBC we are getting 24 like that they are telling. So law schools, I think it changed. When I was registered, several students, they did not join in IIT. IIT they left. Medicine they left. They joined in law schools. They are taking loans to repay the loans. They are taking this law firms or private sector. We can't blame them. They have to pay, otherwise they will be in trouble. So as far as the education is concerned, this aspect, and 2 years are 2 years, what you call training in Judicial Academy, you are telling. If you take this apprentice, if you take after law, I think in one this with reference to apprentice also, Advocates Act prescribed, later on they omitted. In 1995, in one case, Supreme Court insisted, Bar Council amended the rules and they said apprentice is important. And some batches, they did apprentice, but later on Supreme Court struck down that apprentice provision. No need to do apprentice like that. But whether practical experience is required or not, if you see, I will give you one best example, Justice Kailashnath Vanchu. He was the best example. He was the former Chief Justice of India, 10th, 1903 to 1988. He was an ICS officer. He joined as a joint magistrate on 1st December 1926. He became the judge of Allahabad High Court 1947 to 51. and he became the second Chief Justice of Rajasthan High Court 51 to 58, and Judge of the Supreme Court 58 to 67, and CJI April 67 to April 68. He was not having law qualification also. He did not go to court also. Without going to court, in those days, ICS officers, they were appointed as judicial officers also, I think, and he was the chairman of Judicial Reforms Commission. He suggested several good reforms also. And if you see now, what you call this Consumer Protection Act 86 came. And we are thinking about the junior civil judges, senior civil judges, district judges, all this. We are not caring about, we are not taking members of the these commissions, tribunals into consideration. 1996 Act, when they passed, 2 members along with the district judge. He is the president of the commission, and 2 members and 1 woman member. And what is the qualification of those members? Act did not prescribe any qualification. Even 10th standard also, in those days, Professor Sarma, Jammu Kashmir professor, in his report, he did thorough research on this Consumer Protection Act, several articles he wrote, several projects he did. The same was supported by former Supreme Court Chief Justice, former Judge of Supreme Court Justice Prasad Committee report on Consumer Protection Act, if you see. He also suggested, he also made the same comment. Suppose a person who is a party karyakarta, if he did not get any post, then if he goes to Chief Minister, sir, I don't get any post, then there is a vacancy in District Commission, appoint him. And that person who did not pass degree also, he is supposed to guide the district judge. A person who passed degree without law, he is supposed to guide the, what you call, State Commission President, who is a High Court judge, similarly Supreme Court judge. Later on in 1993, they amended the act and they said only the degree is the minimum qualification. If you take NCLT now, 75% in a Supreme Court judgment, Supreme Court judge, he criticized also. 75% of the tribunal members are non-judicial members, particularly if you take NCLT. Almost all, except one judicial, even judicial members are also administrative members. They don't have legal practice, and other 2 members are managers, or chief general managers. They don't know ABCD of law, and that's why they are giving orders contrary to NCLA order. Today NCLAT gave one order, tomorrow NCLT is giving one order contrary to NCLAT. This is the situation now. And NCLT, you saw in Punjab, decorum, Supreme Court said these members, they don't know how to respect all these. 2 members of what you call Haryana, Punjab and Haryana, Chandigarh, they fought with each other before the advocates before NCLT. In NCLT, then president of the NCLT, he suspended the whole work for those 2 members, and he did not allot any work also. So we are seeing only JCJs, district judges, senior civil judges, all these aspects. We are not caring about the members of the other tribunals. If you take Competition Commission, almost all members, 10 members are there. All these are bureaucrats only. Only one retired High Court judge joined, and within 3 months he also resigned. And these commission members, they are dealing with high stake matters. They don't have legal background. They passed BA, after that civics, they joined in service, and they are giving huge order, big orders, and matters are going up to Supreme Court. And this is the problem that we are facing. So with reference to junior civil judges, I am telling, my suggestion, 5-year law degree is too much for law students, and we have to reduce MBBS, BTech, if you take 5 years to 4 years, they reduced. Agricultural BSc, if you take 5 years to 4 years, they reduce. Strictly speaking, in 5th year, 9th and 10th semester, students, we are teaching light subjects, professional ethics, accounting, internship, moot court, like this. All these subjects, we should leave it to Bar Council. Up to 4th, we have to reduce the law degree to 4 years after +2. Seriously, you teach. After 4th year, give them degree, LLB degree or BL degree. Ask them to go out. If they want to go for practice, they have to register with Bar Council, and they have to pass these courses, 9th, 10th semester courses. They can study by themselves, CA. Company secretaries, no one is teaching them. They are studying by themselves. They are issuing only certificate. That certificate, CS certificate, how much value is there? Certificate for ACS, how much value is there? Like that, Bar Council can conduct exam on these aspects, these subjects, and they can conduct bar exam also. Now they are conducting bar. Both Bar Council can conduct. They can see, they can regulate this particular candidate strictly. Meritorious candidates only they should take. In law, we don't have that opportunity. A student who is eligible to get 20 marks also, we are compelled to pass. In state universities, private colleges, if you see, students are not eligible to get 10 marks. They are getting 50, they are passing. And the same persons are going to bar. They are going to judges. They are becoming judges. So this particular defect, if we separate this and apprentice, you have Bar Council has to conduct. After that 1 year, practical experience in courts, the Bar Council can prescribe to become a junior civil judge, or the government can prescribe. Then we will get effective lawyers. See, that certificate of legal practice Bar Council should give to lawyers. LLB degree, forget about. Like CA, a company secretary, certificate of legal practice they have to give to lawyers. And with that certificate, they have to enroll and they have to practice for 1 year. If they want to become JCJ, they can. 1 year experience, 1 year apprentice, these two are sufficient. And if we separate this, quality advocates also we get. And at the LLB stage also, 5 years to 4 years we can reduce, and we can reduce the pressure from the students. So these are my some suggestions as far as what you call the experience and apprentice are concerned. Thank you.
Thank you, sir. To Justice Chelameswar and Justice Navniti Singh, like, you have been the highest stakeholders in the justice delivery system. Like right now we have the esteemed panelists. So, sir, right now the students are having a lot of confusion. They are quite distressed. They are emotionally, like, they're heartbroken at this moment, considering they have lost an opportunity. Sir, we request you both, please give a strong message to the students so that they can continue with the practice, they can accept this judgment and proceed further to join the judicial services in future.
Sir,
Yes, brother.
Was I audible to you?
Yeah, I was. It was.
Some lines of motivation.
See, there is nothing to get disheartened. It is not that some set of students are put at disadvantage and others are gaining an advantage in that. The event is postponed by 3 years all over the country, wherever these boys or girls want to appear. Uniformly, the event is postponed by 3 years. Now, you'll have to wait for an opportunity. See, I mean, I don't want to make a statement which is likely to discourage students, youngsters. What is the guarantee that everybody who appears for the examination will get selected? Obviously, not all of them will get selected. It's a filtering process. Number of posts and the number of aspirants would be a huge variation. The point is, the rule by itself is not depriving you any opportunity. Only thing is postponing an opportunity. Whether you will be able to avail that opportunity after 3 years or not depends on your work and your ability. So don't get disheartened. There's nothing confusing about it. Now, Professor was mentioning about see, exceptions do not make rule. Laws are meant for averages of the society. One Palkiwala, one Vanchu, one Krishna, Krishna Swami. Krishna, okay, Krishna Swami, Aladi. See, they are exceptions. Not every lawyer who has acquired a law degree becomes a Aladi or Palkiwala. So in between, there is a whole range starting from Chelameswar to so many other people. There is a whole range of things. The point is, it is the judgment as it reads is based on the analysis of the experience gained over a period of 20 years. The Supreme Court has come to the conclusion after examining all the material So the experiment did not yield the expected result. The experiment conducted earlier after Shetty Commission report did not yield the right result. Therefore, it was a majority opinion of all the stakeholders, states and high courts and everybody, that an alternative model should be tried. And that is the authority of the, however much the other wings of the state disagree, the legal system is a part of the state machinery. That is the authority of the state. In exercise of the authority of the state, a system is devised. But this is always, there will be disadvantages in law. Income tax law is very, very inconvenient for a lot of people who are making money. But then it is meant for the larger good. Any law for that matter. Any law is bound to create some inconvenience to some section or the other of the society. But then the legislature or the lawmaking bodies keep to the, of course, their understanding to the best of their ability. They take the averages of the society and make a rule, the frame rules or laws, which in their view would benefit the society. So there's nothing to get discouraged about it, disappointed about it. Nothing is lost. The worst perhaps is the event is postponed by 3 years. In between personal problems, somebody wants to get married, somebody doesn't want to get married. They're all unconnected with the system, as Brother Navniti Singh was saying. There are personal problems you'll have to handle. Life is such. You don't get everything in life. In fact, and that the whole evolution of the legal education was being discussed and how the thing progressed from time to time or degenerated time to time. I can only share a personal this thing. Prakasa garu,
Sir.
were you a student of Justice Ramchandra Argal? Sorry, Professor Ramchandra Argal?
Sir, నేను నాగపూర్ నా ఎడ్యుకేషన్ సార్.
Okay.
కానీ రామచంద్ర గారు విన్నాను సార్, విన్నాను.
Okay, he taught us CRPC. The first day he entered the class, he looked at the class and made a very profound statement. Things were different those days. Today, there's a lot of competition for legal education. So, Professor Ramchandra looked at us and said, "Boys, all of you are here because you couldn't be anywhere else," he said.
Sir.
That was the state of legal education when we got into the law college. Now there is a heavy competition, because ultimately, look at it realistically, post-90, the opening up of the Indian economy, the amount of money that is in circulation in the financial markets of India, and proportionately the fee structure of the lawyers, from 1,800 rupees to a senior advocate long back, to 18 lakhs a day today in the Supreme Court to a senior advocate, naturally there is a great, attraction to get into the legal profession. Okay. So anyway, this is by the...
I will just take up from where Justice Chelameswar mentioned. In one of my speeches at the that National Law College at Cochin, this is precisely what I said. In my time, if one were to conduct a survey on the with regard to the number of students who joined law in Delhi University, law faculty, 75% would be not knowing what else to do, join law. It was law by default. It's only 25%.
Yes.
In my class, we were together, Justice Rohington Nariman, Justice Naveen Sanha, all of us. Now, all of us had come. One was preparing for IS. So he wanted to hang around in Delhi University. So law college was the best. Justice Rohington, he was destined.
By choice. He came by choice.
By choice. I didn't know what to do, but I didn't want to go back home. So I came in. Now things have changed, because the moment you come out of school, you have to make a career choice. So now the lawyers are coming in by choice, not by defaults.
Right. And there's nothing wrong in youngsters. There's nothing wrong in youngsters hoping to make money the day there's nothing wrong with it.
It's a conscious choice they are now making.
Yeah. See, ultimately, all the activity in this world is for sustenance. Whether you become a IAS officer or a lawyer or a scientist, eventually it all boils down to some making up some money and making a livelihood. Otherwise, all of us would end up in some ashram or mutt or something like that if you don't have that ambition. There's nothing wrong with it, but only thing is just have some patience. Work for 3 years.
No, and that will be to your advantage.
Yep.
Gaining practical experience of the system in which you have to work. You will be governing that system after some time. So unless you know the basics of the system, it will always be to your advantage. And if seriously taken, you will enjoy and you won't know 3 years passes like this. If you get involved in the system, 3 years is a very short time. And now most of the district bar associations, they have made certain rules where they make mandatory payments to the juniors. So it's not that you are left with no money.
There is if I'm not wasting the time of the gathering, there is an anecdote I would like to tell you people. We had first batch of Andhra Pradesh High Court, 1955, when the old Andhra Pradesh state came into existence. There was a judge called Justice Bhim Shankaram. Incidentally, his grandson was the late Mr. Sitaram Yechuri. Sitaram Yechuri is Bhim Shankaram's daughter's son. So this Justice Bhim Shankaram was a very brilliant man and a very witty person, I believe. I never saw him, I heard. So it is said of him, I believe one of those days, some young lawyer who just enrolled went to Mr. Bhim Shankaram for his blessings and guidance. So Mr. Bhim Shankaram told the young man, well, young man, this is a profession where you have to burn a lot of midnight oil and no senior pays you much in this profession. You will have to fend for yourself. And few years it will be very difficult. Then the boy, with all his optimism, young man's optimism, said, what happens after a few years? It is, I believe, Justice Bhim Shankaram told him very cynically, well, you'll get used to it. That was the state of affairs in the profession those days. Things have changed a lot. In my days, at least in those days when I and Brother Navniti Singh, some of us got into the profession, especially those of us who started in the High Court for the first 5 years, we never had an opportunity to open our mouth, barring asking for an adjournment. Okay, maybe we had some, at least I had some personal level of financial comfort, therefore it didn't trouble me. Then the profession has always been like this, it's always like this. We'll have to wait. And then it doesn't do any harm if you are sincere about it. To use that time properly, it certainly helps you in the long run. Please keep that in mind.
Anything else?
No, sir. Soumya, any questions you have?
Lordship, I fear posing this question to you. I'm in great fear asking you this. A person who has done 3 year law practice, or after, like 2 or 3 attempts he or she gave, and after that he is in position of civil judge junior division, the probability to go to high court is very less. To elevating to high court, the probability to go to high court or elevating to high court is very less. Of those persons who joined at the
Who
age
told
of
you
32 or 34.
Who told you? Who told you? See, if somebody becomes a judicial officer at the age of 30, let us say, after putting in 3 years of service, broadly, some 30 years, there is a very fair chance of that candidate reaching the High Court. Very fair chance. What, brother? What is the state of affairs in Bihar?
Sir, it actually depends from High Court to High Court.
I told you in the beginning, opening of my speech, I said, there's nothing is uniform in this country. Yeah.
So there is HJS also. HJS people also come.
Now, for example, in Patna, in Bihar, it would take a person minimum 15 to 20 years to come to the higher judicial service.
Okay.
And once in the higher judicial service, minimum 15 years. So there is a 30-year.
It will take 15 years as a district judge, is it? That varies from state to state. And
that varies from state to state. And that would, in a way, increase
In South India, it doesn't take that long. You must have noticed in Kerala.
It's much faster there.
Much faster here. It depends. It varies.
And it depends. Like last year, we had elevations at Patna of service judges who were hardly 50. They came in directly through higher judicial service, and within 10 years, they came up. It's a matter of chance. At times,
Yeah, it all depends on
number of vacancies working, the cadre strength, how quickly you get promoted. Now, I know of a person who was in the junior division, and there is a 10% that we call it expressway, where after 5 years or so, he can give an accelerated promotion.
Limited examinations.
Now, by that route, he came, and he really superseded 3-4 batches.
Oh, these things vary. There is no uniform rule in these matters. Varies from state to state, time to time. Things vary.
And these are all incidents of service. You have to bear with it.
Young man, if you are serious about becoming a High Court judge, you better go to the High Court, start practicing there straight away. Well,
Start from Article 226.
That requires gut feeling, sir, because of unemployment, waiting for 35 to 40 years.
See,
there's a difference between profession and employment. Please maintain that distinction. There's a difference between profession and employment.
Yes, sir.
See, in this world, everything depends on chance, Professor. But just to give a thing, Mr. Manmohan Singh was secretary under Pranab Mukherjee. Later, Manmohan Singh became the Prime Minister and Pranab Mukherjee remained only the minister in his cabinet. Of course, he became the president. So therefore, these are all exceptions. I am not talking about. But one thing is this: there is no certainty. Nothing is certain in the universe. They're all approximations. You have to make an attempt. You succeed, you succeed. If you don't succeed, good.
See, the problem is arising is everyone is now equating a profession to a service. They're two different things, two different concepts.
Partly the system itself is responsible for it. Now, where did the Indian judiciary and collegium get this concept of all India seniority for consideration of elevation? Before the transfer policy in 1990, so you became a chief justice in your own high court depending on whether you are young enough or not. And the day you accepted the judgeship, you knew whether you are going to end up as a chief justice or not. This thing. Then all kinds of things. You are simply reduced into kind of a service.
I don't know. I can't follow this system. In one of the collegium things that was made public, I'm talking of that. We understand that he stands as 35 in the All India seniority and is not a chief justice. Yet we think it appropriate to bring him.
Well, of course, there are views and views. It has become a service, that's all, let us say. Justice, value, judgment, our own personal opinions. We may be right, we may be wrong, that's a different story.
The Supreme Court corridors were air-conditioned.
Achha?
Enormous cost.
Now, is that?
Court 1, in front of Court 1, the corridor, Court 1 to 5.
The lawyer's corridor.
Yeah. Glass paneling and air conditioning.
Maybe.
The work was completed about 6 months back.
But I don't know, the glass, will they?
Yesterday, it was ordered to be dismantled.
Why?
Restore Supreme Court to its own glory.
The glory depends on the glass panels, is it?
And that decision has been publicized a lot.
Anyway, no, let us not discuss these things in front of the youngsters. They will get more dejected about it. We can talk privately.
The last few points I want to ask with the lordships. Shetty Commission, the report came in 1999,
Right.
11th November 1999.
Almost 30 years back.
2002, it was said that 3-year law practice is not necessary. Now, again in 2025, when the Law Commission report in 1986 says the intensive training requirement is necessary, and it is much more far better than a law practice with zero financial security. So what was the need of the hour,
No, please
citing this
don't
SETI
ask.
Commission?
Please don't ask us what was the need, because we are not in a position to decide. We are only discussing whether the system, what are our views. I told you in the beginning itself, if I were to be given a choice or somebody were to seek my opinion, I would have suggested take the raw graduates, but put them to 3-year intense training.
Exactly.
That's one view. Mine need not be the only view and the ultimate view, isn't it? That is the beauty of democracy. Democracy is meant for differing views. I would prefer a system like this and design a proper training course. Put them with a judicial officer at 3 years, sometime with a junior civil judge, sometime with a senior civil judge, sometime with a district judge, sometime maybe the High Court. That's also a great experience. I mean, maybe there are others who don't agree with me. The actual on-hands experience in the profession. Well, of course, these are all views of the views and views. You don't ask us what is the need to abandon SETI Commission recommendation. I can't answer.
Just two minutes anecdote I'll explain to show how experience is necessary. A magistrate had just come out of the academy and first posting, magistrate class 3, his court clerk, that Peshkar as we call it in Bihar, he was absent. So he says, oh, he's absent. So he took out his hanky and put it on his table. So all the lawyers would come, the 2 rupees or 5 rupees, which they would pay the court clerk as peshki, this judicial magistrate collected, and the next day when the Peshkar came, says, here is your fee. Now, he did not know what that was.
In fact, there's something, brother, I don't know whether you remember it or not. Setalwad records in his autobiography, and people talk about officers being discourteous, so on and so forth. Setalwad records in his autobiography of a former Chief Justice, deliberately I'm not mentioning the name, it's recorded there. I believe it was a little harsh to the bar. And he records one instance when some lawyer was arguing, it was somehow the honorable judge was not very happy with the argument. He asked, how long have you been practicing? The natural pride of a lawyer, he mentioned about 30 years. Without batting an eyelid, the judge said, you have wasted all the 30 years. Well, we were talking about an youngster being discourteous to the bar. What do you talk about these things? It's all human problem, brother. This world is, it takes all kinds of people to make this world. Courteous, discourteous people, brilliant, not so brilliant, all kinds of people will be there. Anyway, I think, do we stop it here?
Nothing to be disheartened. It's only postponement of chance.
That's right. And one thing I can say at the end of it, I wish all the youngsters a very bright future. Don't get disheartened. Work hard. God bless all of you.
Yes, sir.
Good night.
Good night.
Thank you so much, Lordship. Thank you,
Thank you so
Lordship.
much.
Thank you. Thank you, Honorable Vice Chancellors. Thank you. Thank you, sir.
Right.
Thank you. Thank you.
Hello. Amma Cheppu.
Thank you, Professor D.S. Prakasa. Thank you.
Thank you, Sanjay.
Thank you.
Thank you.